ಹಲೋ ಹಲೋ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ.
ತೆಗ್ದಿದ್ದೀನಿ. ನೀವು ಮಾಡ್ತೀರಾ? ಆಯ್ತು, ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ ಸರ್. ಅದ್ರಲ್ಲೇ ಇಟ್ಟಿದ್ದೀನಿ. ಅದ್ರಲ್ಲಿ ಇದೆ ನೋಡಿ, ಇಲ್ಲಿ 29 ಡಿಸ್ಪೋಸ್ ಆಫ್ 5918. ಅದು 17. ಇನ್ನೊಂದು ಪ್ರಿಂಟ್ಔಟ್ ತೆಗ್ದಿದ್ದೀನಿ, ಅದ್ರದ್ದು ಆರ್ಡರ್ ಕಾಪಿನೇ ತೆಗ್ದಿಲ್ಲ. 29 ನೋಡಿ, ಇಲ್ಲಿ ಇದೆ. ಇದ್ರಲ್ಲೇ ಇದೆ. ಅದ್ರಲ್ಲಿ ಅದಲ್ಲ ಸರ್, ಬರೀ ನಾನು ಹಿಂಗ್ ಲಿಂಕ್ ಮಾಡಿ ಹಾಕಿದ್ದೀನಲ್ಲ ಅಷ್ಟಲ್ಲೇ ಅವ್ನು ಮಾತ್ರ ಡಿಸ್ಪ್ಲೇ
ಹಿಯರಿಂಗ್ ಇದೆ, ಎವಿಡೆನ್ಸ್ ಇದೆ, ಸೆನ್ಸ್ ಇದೆ, ಇಂಟು ಆಗ್ತಿರೋದು ಮಾತ್ರನಾ? ಓಕೆ, 18 ಡಿಸ್ಪೋಸ್ 17 ಪ್ಲೇಗ್. ಓಕೆ, ಕಾನ್ಫರೆನ್ಸ್ ಇರ್ತಾನೆ ಮತ್ತೆ ಆರ್ಡರ್ ಡೇಟ್ ಹಾಕ್ಬಿಡ್ಬೇಕಾಯ್ತು ಬಿಡಿ. ನೋಡ್ಕೊಳ್ಳೋಣ ಎರಡೇ ಅಲ್ವಾ? ಎರಡು ಸಬ್ಮಿಷನ್ಗೆ ನಾವು ಒದ್ದಾಡೋದು. ಅವ್ರು ಬಂದವ್ರು ಮೇಡಮ್ ಅಷ್ಟೇ. ಮೇಡಮ್ ಇದ್ಯಾವುದು 29?
ಆರ್ಡರ್ ಕೇಳ್ತಾರೆ ಅಂತ ತಂದಿ.
ಆರ್ಡರ್
ಸೀರಿಯಲ್ ನಂಬರ್
ಅದೇ ತರ ಅದ್ರದ್ದು
ಮಾರ್ಕ್ಸ್ ಮಾತ್ರ ತೆಗೆದಿದ್ದೀನಿ ಸರ್. 25
ಸೆಕೆಂಡ್ ಮೆಟ್ರೋ ಫೈಲ್ ಬೇಕು. ಈ ಕಡೆ 2.5 ಆಯ್ತು. ಯಾವುದು ಅಂದ್ರೆ ಏನು ಸರ್ ಹೇಳೋದು? ಪರಮೇಶ್ವರಪ್ಪ ನೀವೇನಾ? ಹಾ, ತೆಗಿದ್ಯಾ ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತ ನಮ್ಗೆ
ಸ್ಟಾರ್ಟ್ ಅಲ್ಲಿ ಇದು ಬರುತ್ತೆ ಸರ್ ಇದರಲ್ಲಿ
ಹಲೋ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಡೇಟ್ ಕೊಡ್ತಾ ಇಪಿಲ್ ಆಗಿದಾಗ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತಿದ್ರೆ ಅದ್ರ ಪ್ರಕಾರ ಆರ್ಡರ್ ಆಗಿತ್ತಾ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಕಾಂಪ್ರಮೈಸ್ ಹೈಕೋರ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನಂತ 25 ಲಕ್ಷ ಮಾಡ್ಕೊಳತ್ತೇನಾ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಆಗಿದೆ ಈಗ ಕೆಡಿ ಬಿಲ್ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ದ ನಿಮ್ಗೆ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ದ ಏನ್ ಮಾಡಿದ್ದೆ ನಾವೀಗ petitioners have withdrawn 25 lakhs from KDB also and
ನೀವು ಲೈವ್ ಇದ್ದೀರಾ ಬರ್ದ್ಬಿಡಿ ಸರ್ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಸರ್ ಬೆಸ್ಟ್ ಅದು ನಿಮಗೂ ಸೇಫ್ ನಮಗೂ ಸೇಫ್ ನಂಬರ್ ಹಾಕಲ್ಲ
ನಂಬರ್ 17 ಅಲ್ಲ ಇದು
ಹಾ ಸರ್,
ಪೋಸ್ಟ್ ಮಾಡಿದ್ಯಾ?
RPD ಮಾಡಿದ್ದೆ ಒಂದು.
ನನ್ನ ಫೋನ್ ನಂಬರ್ ಹಾಕಿ ಅದಕ್ಕೆ.
ಇಲ್ಲ, RPD ಫೋನ್ ನಂಬರ್ ಹಾಕಲ್ವಲ್ಲ ಸರ್ ಅದು.
ನನಗ್ ಬಂದಿದೆ ಟ್ರ್ಯಾಕಿಂಗ್ ಡೀಟೇಲ್ಸ್. ಎಷ್ಟು 4 ಹಾಕ್ತೀಯಾ?
ಬಂದಿದ್ಯಾ?
ನಂಬರ್ ನಂದು.
ಮೇ ಬಿ ಅವರು ಅಲ್ಲಿ ಸೇವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ. 2 ಇದಿದೆ ಅವ್ರ ಹತ್ರ ಸೇವ್ ಇರೋದು. ವೆಂಕಟೇಶ್ ಆರ್ ಭಗತ್, ಒಂದು BL ಭಗತ್ ವಾಚಿಂಗ್.
Lordship kindly, my lord.
Paid by submissions.
With your lordship kindly, my lord.
21.
My lord, serial number 15, my lords.
One ನಿಮಿಷ. 18. God. In reason, I know what is the reason? Execution petition is disposed of. What's your name? Finance on counsel appearing on behalf of Sanmet RB, counsel for the petitioner, submits that the execution petition, for which the above.
My lord, court proceedings are muted, my lord.
For which the above writ petition arises out of has been disposed by the trial court, by the execution court, rendering the above petition infructuous. Hence, he has filed a memo for withdrawal of the above petition, accepting his submission, and the memo to this petition is dismissed as withdrawn.
Serial number 6, no?
6 is not for mentioning, Mr. Reddy.
No, it has become infructuous.
Barana. 15 to 21 of page 3.
My lord, serial number 15, my lords. Lordship may kindly note on Monday, my lords, for today we have some personal inconvenience.
Have you informed the counsel for the respondent?
No, my lords.
Bada. Once they come.
Please.
Page number 4. Serial number 22 to 25. Page number 5. Serial number 26 to 32.
ಇಬ್ರು ಮಾತಾಡ್ಕೊಂಡಿದ್ದೀವಿ. You oppose it. If you oppose, you won't give Mr. Chinnappa Reddy time. So, ನಿಮ್ಮ ರಿಕ್ವೆಸ್ಟ್ Chinnappa Gowda, Learned Counsel for respond number 2 to 5 seeks for a short accommodation. Learned Counsel for the petitioner has no particular objection. Released on 22nd. ಸೋಮವಾರನ ಮಂಗಳವಾರನ ನಿಮ್ಗೆ ಯಾವ್ದು ಒಳ್ಳೆ ದಿನ ಇದೆ? 21st. ಅವ್ರಿಗೆ ಒಳ್ಳೆ ದಿನ ಅದು 21st. 27. ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ಇನ್ಫಾರ್ಮ್ ಮಾಡದೆ ಬೇಡ. Any interim order? 28. Ms. So-and-so, Learned Counsel for the petitioner submits that the sole petitioner has expired. She seeks for 3 weeks time to take necessary steps to bring the legal representatives of the deceased petitioner on record. Released on 7/3. 7/3.
Page number 6. Serial number 33 to 38. Page number 7. 39 and 40.
With your lordship kindly, my lord. Serial number 39, my lord. The sole petition has expired on 19/7/2019, my lord.
Who is expired?
But the sole petitioner, my lord, has expired on 19/7/2019. Steps are not yet taken, my lord.
Your lordship, when I appear for the petitioner, the lordship may grant me some time to take steps.
Learned Counsel for the petitioner seeks for a short accommodation to take necessary steps to bring the legal representative of deceased petition number 1 on record, relist on 8-3.
Please, please.
My lord, serial number 40, my lord.
40.
40, my lord.
Yes.
And the parties have filed a compromise petition in the execution proceedings, and the execution petition is closed as fully satisfied. So nothing survives in the petition. my lord.
You are appearing for whom, Mr. Avinash?
I appear for the petition. V. Ravi Prakash.
The Avinash, learned counsel, appearing on behalf of the Ravi Prakash. Learned counsel for the petitioner submits that in the execution proceedings out of which the above writ petition arises out of, the parties have filed a compromise petition, and the said execution proceedings has been disposed as fully satisfied.
Fully satisfied.
He therefore submits that the above petition does not survive for consideration. Accepting his submission, the petition is dismissed as infructuous. As close of court.
Much of.
Entry ಮಾಡಿದ್ರೆ wait ಮಾಡಿ.
The lordships can,
Not without informing. Sale number 28, wait. ಏನು ಮಾಡಿ?
with the lordships kindly, Milan.
Yes. ಹೇಳಿ.
Not serial number. I'm sorry, I could not mention serial number 19. I appear for the petition. I appear for the petitioner. I am told, respond counsel, there is some bereavement in his family, counsel's family.
Okay.
Scalcharia's family, some bereavement.
Yes.
Lost my habit after 2 weeks, Lord.
It's submitted that there is a bereavement in the family of the council for the respond number 1 to 3. And released on 28 to.
Please, ma'am.
28 to, Mr.
Orders matter. Seal number 1, Narayan M. Narayan M.
And appears today also, after the objections have not been complied with for the last 2 years. It appears that the petitioner is not interested in prosecuting the matter, and the petition is dismissed for non-prosecution.
Seal number 2, Parameshwarappa MV.
ಏನಾಗಿದೆ ಪರಮೇಶ್ವರ್ ಅವರ? Not good. The Karnataka learned counsel for the petitioner has filed a memo seeking for withdrawal of the above petition is not set. Accepting his submission and the memo, the petition is dismissed as not set.
Seal number 3, Shetty Deepak. Deepak Shetty.
None appears for the petitioner. One more week's time is granted to comply with office objection if the same is not complied with by 23/2/2022. The above petition will be liable to be dismissed for non-prosecution, released on 25/2.
Seal number 4, Sanchay J. Nandan.
Yes. Now we'll have to impose another 10% as administrative for you coming here. ಇಷ್ಟೆಲ್ಲ page number? Will notice has to go. Can't pass an order without notice. So, the office has raised the objection as regards how the response had been made as parties when they were not parties to the proceedings in miscellaneous number 1 of 2019. I will submit that the said miscellaneous 1 of 2019 had been filed seeking for refund of the court fees which had been wrongly remitted by invoking section 67 of the Karnataka Court Fees and Suits Valuation Act 1958. Since the application had been filed in the very court where the deposit had been made, there were no respondents. However, since a challenge has been made to the order passed therein, they said the representative of the said court has been made a party to these proceedings. Accepting a submission, the office objections are overruled. Registry is directed to issue notice to the respondents returnable by 24/2022.
Number 5, Manjunath HN.
Manjunath? None appears for the petitioner. 2 weeks time is granted to comply with the office objection in this time. 9(3).
Still number 6, C. Shankar Reddy.
Not the original suit, not out of which the present writ petition arises, not has already been disposed of, not under a judgment and decree.
Yeah, on bridge.
Houdu. Therefore, not reserving liberty to raise these grounds not in the regular appeal that may be filed. Not
So
this
the appeal has gone against you.
it has gone against me. At the time of when the matter was posted for arguments, not without hearing me, matter was posted for judgment. Immediately, I filed a recalling application, not that has also been rejected, and not the matter has been decreed. I am the defendant, not for the trial court.
C. Shankar Reddy, learned counsel for the petition, submit that OS number 345 of 2015, out of which the above writ petition arises out of, has been decreed against the petitioner. He seeks permission to withdraw the above petition with liberty to raise the issues raised in the above petition in the appeal proposed to be filed by the petitioner. Reserving such liberty is available under law. The petition is dismissed as withdrawn.
Number 7, Baker City H.
Yes, Dina. ಮುಗಿಸ್ಬೇಕಾ Jacob Chetty, learned counsel for the petitioner, seeks for 2 weeks time to comply with the office of the on 3/3.
Number 8, but Ramchandra Ganapati.
What? None appears for the petitioner. 3 weeks time is granted to comply with office objection. Duration 9 weeks.
Bill number 9, Shankar Narayan Bhatt.
Madam.
Bill number 10, Revanna PC. Bill number 11, Prasanna BK. Sheetal Soni. Number 12, Devendrappa H.
I appear for the petitioner in this matter, my lord. In this matter, my lord, small office objections are there, my lord. The urgency in the matter, my lord. Office objections, all counsels to accept the wakalat marked by marker to be removed from annexure R3 and preamble portion of annexure E to be furnished, my lord. Only
Page number. Annexure E is at page number.
annexure E is at page number 51, my lord.
What are you agreed by, madam?
Order is that annexure C, my lord.
No.
Imprint order is annexure C, my lord. We had filed an application before the trial court, my lord.
Annexure C andre annexure page number helbeku.
I'll tell my lord.
Annexure C is application under 26 rule 10.
Yes, my lord.
What are you challenging?
I have challenged the order which has been passed by the Honorable Court, wherein I had filed an I and Order 26, Rule 10A of CPC, my lord, seeking permission of the Honorable Court for drawing the blood samples of the second plaintiff, my lord, and telling the same with the blood samples of the this petitioner, my lord, because the first defendant disputed that that second plaintiff is not the daughter of the this petitioner, my lord.
They want a paternity test.
Yes, my lord.
And that has been dismissed.
Yeah, that has been dismissed, my lord. The matter is now for arguments, my lord.
You notice aglebekala, madam.
Yes, my lord. Because the matter is slotted for arguments, final arguments, my lord.
Why did you wait till now to file the application?
My lord, due to Corona, my lord, the matter was not listed, my lord.
2010 suit, madam.
Yes, my lord.
You filed the application after 12 years. If there was some issue on that, you should have filed the application earlier only for paternity when there's an issue.
Issue was that they have not filed at the later stage, they have filed it, my lord.
When is it posted for arguments?
Today it is posted for arguments, my lord, before the trial court.
They'll permit you to serve the counsel for the respondent.
Yes, my lord, I will do that, my lord. It is at Chikkarapura, my lord.
A week's time is granted to the petitioner to comply with the office of the. In the meanwhile, issue notice to the emergent notice to the respondent. Returnable by 28 to 2022. The counsel for the petitioner is also permitted to serve the counsel for the respondent in the trial court.
Much obliged.
The hearing to be 28 to 2022.
Number 13, Harish HB.
R3 and R5 relationship.
1, 2, 4, and 6. You got an interim order and interim order is there. And you still haven't taken steps. Why should we not think that you are delaying the matter because of the interim order?
And after the proceedings, from 21 2, I have taken the steps. So 1, 2, and 4, the decision is
1, 2, and 4 reside in the same address.
and only 6 will not become contact steps now.
Mr. Narayan,
For R3 and R5, Your Lordship.
what about 1, 2, 4, and 6? Any conflict, you can accept notice.
No, they are different clients, Your Lordship.
They're different. An interim order was passed on 21/4/2021. Respondent number 1, 2, 4, and 6 are listed.
Happy.
Harish Shetty seeks for a day's time to make payment of necessary process fee and furnish copies for such service. If the same is furnished, the interim order earlier granted would stand extended till next date of hearing. If the process fee and copies are not furnished by end of day 16/2/2022, the interim order will stand automatically vacated. Counsel for the petitioner is also permitted to serve the counsel for respondent number 1, 2, 4, and 6 in the trial court if they are represented. If they are represented. Previous on, if the process is paid, registry is directed to issue notice, another notice to respond number 1, 2, 4, and 6, returnable by 22/3/2022, previous on 22/3.
Number 14, K. Ravishankar.
Ravishankar. And appears for the petitioner. The office objections have also not been complied with. The office
Group matters. Number 15, Dwarkanath HS.
I'm appearing for the petitioner in this matter. I request my lord, this matter may be taken up for Monday. Today we have some personal inconvenience.
respondent yaru ilvalla to object to the counsel for the petitioner seek for a short accommodation. None appears for the respondent. Previous on 9/3.
Interim order may be extended.
Order earlier granted is extended to next day.
Number 16, Amit Kumar. 16.
ಏನಾಗಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ತಲ್ವಾ ನನ್ನ appears in the entity justice Lamma opportunity is granted for the parties to be represented. Previous on 10/3.
21, PM Narayan Swamy. Sorry. Serial number 17,
Doesn't survive for consideration for what reason? So nobody has come forward to. No? Hmm. Hmm. What was the IA about? What was the IA about?
First respondent is the son, second report on the daughter.
Where is IA for? Limit the rent. Sunita, there are counsel for the petitioner. Submit that during the pendency of the above proceedings, the petitioner has expired. The suit in case number 6112 of 2013, out of which the above petition arises, was one for partition. And in the said suit, an application under section 151 of the Code of Civil Procedure had been filed seeking for a direction to defendants to remit the rents to the first, remit the rent. To submit that defendants are the legal representatives of the petitioner, and there are no other legal representatives who are interested in prosecuting the matter. Accepting the said submission, the writ petition is dismissed as abated. What was that application? IA under which provision? Which provision did you file the IA interlocutory application under? 151, 144, 17.1, 151, seeking for redelivery of possession.
Serial number 18 disposed of, 19 adjourned. Serial number 20 Nagaya.
My lord, appearing for petitioner in this matter, my lord. My lord, the file has been misplaced, my lord. I'll seek a new file from the office and we'll do the argument, my lord. I seek for a 2 weeks accommodation, my lord.
Thank you for the petitioner submitted the file. The above matter has been misplaced.
Please, my lord.
And to rebuild the file and make it submission. Do this on 16/3.
Oblige, my lord.
Number 21 PM Narayan Swami.
Yes, love. Represent the respondent.
ಸ್ವಲ್ಪ ಕ್ಯಾಮ್ರಾ ಕೆಳಗೆ ಮಾಡ್ಕೊಳ್ಬೇಕು, ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ನೀವು. ನಿಮ್ಮನ್ನು ನೋಡಿದ್ರೆ ನಮ್ಗೆ ಸಂತೋಷ. ಎಸ್ ಹೇಳಿ. ಸ್ವಲ್ಪ ಮೈಕಲ್ಲಿ ಮಾತಾಡಿ ಅವ್ರಿಗೆ ಕೇಳಬೇಕು. ಆನ್ ಮಾಡಿ.
The petitioner filed application order 13 rule 8, ma'am.
13 rule.
Please, ma'am. Section 34 and 35 stamp park, ma'am. The petitioner insufficient stamp duty was paid, ma'am. I filed application that the trial court might dismiss my application, ma'am. Reasoning, ma'am. Annexure A, ma'am. Page number 14, ma'am. IA number 3 is filed by the advocate for the applicant, the defendant directing to the plaintiff to pay the stamp duty on exhibit P2. Admittedly, that this is a suit filed by the plaintiff against the defendant for recovery of money. Moreover, the plaintiff is not insisting for purpose of agreement of sale. Exhibit P2, the plaintiff has requested only recovery of the money on the basis of the exhibit P2. Looking at the facts and circumstances of the case is where the suit specific performance of the contract, the basis of agreement, then the should claim on the registered documents. But this is suit for recovery of money based on the agreement of the sale. Under such circumstances of this, the discussion laid down by the lordship, the supra ruling is not applicable. The present facts of the case, therefore, with the observation, I am of the opinion that the application filed by the applicant defendant divided the merits of reserve, the dismissed according to the following in the orders. Agreement of sale, exhibit P to my already marked my document made. The 1,66 lakhs for the amount was not. Sale agreement.
The recovery issue.
Please, man.
You want the stamp duty to be paid on the basis of the value of the property in the agreement of sale.
Agreement of sale, man.
Then ಯಾವ basis ಮೇಲೆ why do you contend that?
Judgment, man. Section 3.
Same judgment ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ರೈಸ್ ಮಾಡಿದ್ದ ಅದೇನಾ? ಹೊಸದ ಬೇರೆನಾ? ಅದೇನಾ? Not 2016 Karnataka. ಅದೇ ರೀ.
ಅದೇನು? Same judgment.
What do you want to rely on? Vistara.
Para number 14, man. For the mistake of the trial judge is in not deciding the objection raised on the said instrument when tendered in the evidence of the before the reviews the evidence, the parties cannot be made sufficient since the said documents is inadmissible in evidence and as the competent prohibition and admitting such insufficient stamp documents in evidence and in view of the submission made the defect stamp duty on penalty would be paid the trial document mark.
You should file it.
Present. 2 days time I would present documents.
Let us have a copy on the other side. They should have it. It should not be caught by surprise, alva? Do you have a copy of this decision and
No, Miller, I do not have a copy. Right now, I do not have a copy. 2, the agreement itself is not produced. Agreement also to be produced. Agreement is also not before.
ಅದು ಇವಾಗ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Council wants to hand it over across the bar. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕಾಪಿ?
ಇಲ್ಲ, ಮಾತ್ರ ಇಲ್ಲ.
Council for the petitioner seeks to rely upon the decision in ILR 2015 Karnataka 1984 as also wants to produce a copy of the agreement of sale. Subject matter of the application, which is being dismissed by the trial court by the impugned order. Copies of the same have not been furnished to the council for the respondent. And council for the petition undertakes to furnish the same within 3 days from today. Read this on 25 to
interim matter be extended. Please.
Interim order earlier granted is extended till next day.
Much of it.
Number 22, Venkatesh R. Bhagat.
But I appear for R1. My difficulty, my lord, is I don't have papers.
Lord, I'm appearing petitioner. Lord, I seek accommodation, my lord.
So what is your difficulty, Mr. Raghunath?
My petition papers are not available in my office. I'm sorry, my lord. I'll have to take a copy from my learned friend only.
Sarvagitta.
ಅಲ್ಲ ನಾನು ಕೇಳ್ಬಿಟ್ಟು ಅವ್ರ ಹತ್ರ ತಗೊಳ್ತೀನಿ.
Sorry.
I'm sorry, my lord. I'm sorry.
You want adjournment?
Please, my lord.
Yes, Dina.
2 weeks, my lord.
Interim order extend ಮಾಡಲ್ಲ.
My lord, senior is not well, my lord. For that purpose.
Reason ಕೊಡ್ಬೇಕು ಅದಕ್ಕೆ. Very adjournment ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Counsel for the petitioner, on behalf of the arguing counsel for the petitioner, an adjournment is sought for on the ground that the arguing counsel is unwell.
Please,
9 interim order earlier granted is extension next date appearing.
Much obliged.
Madhukar Nadi.
Mr. Nadik. Trial court ಅಲ್ಲಿ ಏನಾಗಿದೆ ಮೇಡಮ್? ಅಲ್ಲ, after the filing of this, there is no interim order. So trial ಇನ್ನ ನಡೀತಾ ಇದೆಯಾ ಮುಗೀತಾ?
It is pending. Nothing has happened.
Right?
I'm going to responding to the applications.
None appears for the petitioner. None appears for the petitioner today also. There is no representation on the earlier date of the hearing. If none were to appear for the petition on the next date of hearing, the petition will be liable to discuss for non-person. Released on 25/2. ಹೌದು ನೋಡೋಣ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
ಶಿವಪ್ರಕಾಶ್. MD Raghunath for R1.
Raghunath.
Shivaprakash.
None appears for both the parties. Released on 7/3.
Still number 25. Kotiga Ramesh.
None appears for both the parties. Released on 7/3.
Urgent. Still number 27. Narsim Murthy GV.
My lordship, 24th date.
24th date. Mr. Tigidi.
Veerna G. Tigadi. Sir, unmute yourself, sir.
I'm for petitioner. I'm for respondent number 1, my lord.
Petitioner wants an adjournment.
Please, your lordship, may grant me.
When I counsel for the petitioner seeks for a week's accommodation. Released on 24/2.
Film 28. Kevin Narasimhan.
Not for the petitioner, my lord.
Rupesh. Counsel for the petitioner seeks for a week's accommodation. None appears for the respondent. Released on 8. Interim order earlier granted.
8/3, my lord. Placed. Interim order.
Earlier granted is extended.
Great.
ಮುಂಚೆನೆ ಫೋನ್ ಮಾಡಿ ಮಾತಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗಿದೆ. Have you registered on the advocate registration?
Not?
Have you registered in the advocate registration portal?
No, my lord.
Register ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಫೋನ್ ನಂಬರ್ ಸಿಗುತ್ತೆ. So next time when you appear, when we ask this question, your answer will have to be.
ನಂಬರ್ ಫೋನ್ ಮಾಡು.
Number 29, Rajanna L. For the petitioners, my lord.
The respondent note. My execution notes have been closed on 2018 itself.
Filed by the JDRs against the order dated 17/6/2017, my lord.
May I please, sir?
IA number 1. Time.
ಅಲ್ಲ execution ಕ್ಲೋಸ್ ಆಗಿದೆ. It has become infected.
Execution dismiss ಮಾಡುವಂತ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅದು ಕ್ಲೋಸ್ ಆಗಿಬಿಟ್ಟಿದೆ on 5/9/2018 itself.
Execution petition close ಆಗಿದೆ on 5/9/2018.
ಹಂಗಿದ್ರೆ
We must learned counsel for the respondent submit that the execution proceedings.
It dismissed for non-prosecution on 5/9/2018.
Petition number 19 of 2014. From and out of which the above petition arises out of has been dismissed for default on 5/9/2018. Message is submit that there will be no purpose in considering the above petition. Learned counsel for the petitioner, the Rajanna L. Learned counsel for the petitioner, submit that irrespective of the situation, the petition may be dismissed. Accepting the submission of both the counsel, the petition is dismissed.
Please. Seal number 30, P.S. Nagraj.
I appear for the petitioner, my lord.
I appear for the respondent, will.
My lord, the defendant's writ petition.
This, my lord, one submission, my lord. The second petitioner is died.
Just a moment. 1 minute. ಎಲ್ಲ ಅರ್ಜೆಂಟ್. ನಿಮಗೆ ಬರಗೆ ಸಿವಿಲ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ WP CPC CRP ಅಲ್ಲಿ ಬರಕ್ ಮುಂಚೆ ಒಂದು ಈ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಹೋಗಿ ಚೆಕ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ.
ಏನಾಗಿದೆ ಫೈಲ್ ಪೇಪರ್ಸ್ ನಾನೀಗ ತಮ್ಮ ಪೇಪರ್ಸ್ ಇರ್ಲಿಲ್ಲ ಎಲ್ಲ ಹುಡುಕಿ ಹೋಗಿ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದೆ. ಅವ್ರಿಗೂ ಒಂದು ಕೊಡೋಣ ಅಂತ ಅಂದು
ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ಸ್.
That is the difficulty.
ಹೇಳಲ್ಲ.
There is a conditional decree. You are not brought to the notice of the court also. ಕೋರ್ಟ್ನವರು ನೋಡಿಲ್ಲ, ಎರಡು ಸೈಡ್ ನೋಡಿಲ್ಲ. ಒಬ್ರು ಖಾಲಿ ಮಾಡಿಸಿದ್ಮೇಲೆ ನಿಮ್ಗೆ ಅಲ್ಲಿವರೆಗೂ ಖಾಲಿ ಮಾಡಿಸೋವರೆಗೂ ಇಂಜೆಕ್ಷನ್.
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ anybody, be it a lawyer, litigant, whoever, can go and input the number and get the status.
ನಾವೇ ಮಾಡ್ಕೋಬೇಕು.
ಮಾಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು.
Notes even in my
2017 matter.
Even in my case notes, I got an information from that.
ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ.
ಇದು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇನ್ನೂ ಒಂದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ರೆ you will have a dashboard where the latest symptoms of the case will come to the dashboard.
ಹೇಳಿದ್ರೆ ನಮ್ಗೇನು ಗೊತ್ತಾಗ್ತದೆ.
ಯೂಸ್ ಮಾಡಿದ್ರೆ ಯಾರು ಏನು ಹೇಳಕ್ ಬೇಕಾಗಿಲ್ಲ. ಅದು ಬರುತ್ತೆ. ಇವಾಗ ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಇದೆ, ಗೊತ್ತಿದೆಯಾ ನಿಮ್ಗೆ? ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಹೋಗಿ ಸರ್ವಿಸ್ ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತಿದೆ. ಎಲ್ಲ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲೂ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ಹೋಗ್ಬಿಟ್ಟು ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟು ರಿಜಿಸ್ಟರ್ ನೀವು ಅದಕ್ಕೆ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ನೀವು ಒಂದ್ಸತಿ ಟ್ಯಾಗ್ ಮಾಡಿದ್ರೆ ಲೇಟೆಸ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ವಿಲ್ ಬಿ ಅವೈಲೇಬಲ್ ಅಟ್ ದಿ without even any problem. Use ಮಾಡಿ facility. Yes, Mr. Abdullah, you are saying something.
In this, second petitioner is died in the year 2020, my lord. I am the plaintiff. I have brought the LRS record in the trial suit. But here the LRS have not been brought on record.
The second petitioner is expired, Mr. Abdullah.
Yes, my lord.
But I will verify it.
Mr. Nagraj?
I have no information. I will get the information, my lord. I will bring the LRS.
Because I am the plaintiff there.
You are the plaintiff, Mr. Abdullah?
Yes, my lord. I filed an application.
You
also.
bought the legal representatives on
Yes.
record there.
Yes, my lord. By substituted service.
But anyway, they are on record now.
Yeah, they are on record.
C.I. Abdullah, Learned Counsel for the respondent, submit that the second petitioner has expired and our legal representatives have already bought on record in the suit pending before the trial court. Sri B.S. Nagaraj, Learned Counsel for the petitioner, submits that he has no instructions. He would verify the same and take necessary steps, given 3 weeks' time.
Alright, interim order may be extended.
There is no interim order, my lord.
My lord, interim order is there continuously, it is extended.
What interim order? The suit
No,
is going
stay of
on.
all further proceedings, sir.
Interim order, Mr. Nagaraj.
Day-to-day proceedings is going on, my lord. My application is allowed and
Application is, it is a different question. Further hearing is concerned, you see the order dated 9th August 2017, and
after that
thereafterwards,
there is no extension.
no, thereafterwards it is extended October 2017, 9th October.
As per the this thing, particulars of
And
the
then,
suit, my lord.
September 2017. I have got every.
Mr. Abdullah.
Yes, my lord. Now the matter is posted for arguments, my lord.
Just one more, just one more. Very hard. On the last date, it's been extended, Mr. Abdullah.
Yes, then my lord.
17/10/2000.
Yes, anyway, he has to bring the LRs, my lord.
Interim order earlier granted is extended to next week.
Number 31, Kalyana.
Appear for a petitioner in this case, my lord. My lord, dependent's writ petition.
My lord, for the response.
Ready, madam?
The dependent filed an application for amendment of written statement. The said application was rejected by the trial court. Only on the ground, my lord, those the proposed amendment could be urged at the time of arguments. It is in the nature of arguments. Therefore, only on that ground, my lord, the application is rejected. My lord,
Where is your
page
amendment
number,
application?
Lord, 13, page number 13, my lord.
My lord, this is the second amendment which they have sought, my lords. There, nothing had stopped them.
Madam, you can submit once your turn comes.
Please, my lords. Please, my lords.
My lord,
where is the application, Mr. Kalyan?
My lord, application, my lord, is at page number, my lord, 38, my lord, annexure B.
38. At what stage was this application filed, Mr. Kalyan?
My lord, this was filed at the stage when the matter was posted for cross-examination of DW1. After leading evidence, the defendant filed this.
Why was it not filed earlier?
My lord, due to inadvertence and oversight, my lord, the same could not be stated, my lord, and it is
the explanation for what is the explanation to satisfy the requirement of proviso to Rule 17?
My lord, so far as the proviso is concerned, my lord, when an amendment is sought in the written statement, It should be liberally construed, my lord, unlike my lords of the plaint.
All amendments will be liberally construed, subject to you satisfying the requirement of the provision.
Yes, sir, please, my lord. When it comes to the amendment of the written statement, it should be liberally construed than the amendment of a plaint, my lord.
Kalyan will again ask you, what is your amendment or what is your ground to satisfy the requirement of proviso to Rule 17 of Order 6?
My lord, para number 2 and 3 of the affidavit, my lord, stated. The para number 3, my lord, may I read, my lord? Is submitted before adducing my chief examination. I have not gone through the plaintiff's vendors title deeds. Since the plaintiff
only attracting 79 AP is what you have said, not on the fact.
Yes, my lord, in the para number 2 also it is said with regard to 79 AB. In para number 2 of the.
We'll permit you to raise it as a ground of argument, Mr. Kalyan.
My lord, so far as my lord 79 AB is concerned, my lord, it could be raised as an my lord in the nature of an argument. But when it comes to para number 15C, my lord, unless I raise these points, my lord, in my.
But what is the of 15C? What is the explanation you have given?
Please, my lord.
What is the explanation you have given to satisfy?
My lord, the explanation is, my lord, it was not within his knowledge. One after the examination chief of the plaintiff, and after the documents were marked, then he came to know that all these aspects, my lord, and he sought for he filed an application for amendment. That's what the explanation given. And even the statement of objections, my lord, filed by the plaintiff, para number 5 of page number 42.
One for permanent injunction, restraining from interference, plaintiff peaceful possession.
Yes.
Now you want to convert that into a title suit?
My lord, not title suit, my lord, just is incidentally, my lord, the trial court may in a suit for bare injunction may look into the aspect. Unless, my lord, I raise a point, my lord, the defense is taken. The trial court may not look into incidentally with regard to the title.
Sorry. The petitioner is before this court seeking for the following relief. US number 54 of 2015. Sorry. Application IA number 11 had been filed under Order 6 Rule 17 of the Code of Civil Procedure by the petitioner who was the defendant therein seeking for amendment to the written statement by introducing 3 new paras. The said suit in voice number 54 of 2015 has been filed by the plaintiff respondent herein seeking for injunction restraining the defendant from interfering with the plaintiff's peaceful possession and enjoyment of the suitable property. Correct. By way of the amendment, the suit was posted for cross-examination of
DW1.
DW1 when the application for amendment came to be filed. In the said amendment application, what is sought to be introduced is a contention that the purchase by the Government Employees House Building Society and a subsequent sale thereof in favor of the plaintiff is in violation of Section 79A and 79B of the Karnataka Land Reforms Act. Correct. The said application was objected to and the trial court dismissed the application on the ground that contention raised by way of amendment is a legal argument which is always open for the defendant to raise during the course of argument. It is agreed by the same that the petitioner is before this court. The Kalyan Ramchandra Learned Counsel for the petitioner would submit that the amendment sought for is required to effectually decide the dispute between the parties. It was required of the defendant to, in his written statement, plead about the violation of the provisions of section 79A and D of the Karnataka Land Reforms Act by the society which has sold the site, which has formed and sold the site to the plaintiff. Since there is a violation of 79A and D, the plaintiff would not derive any title to the property, which ought to be looked into by the trial court. For contra, Ms. Brinda Verma, Learned Counsel for the respondent, would submit that the trial court has considered all the aspects in a proper perspective. The order passed is proper and correct. There is a second amendment application which has been filed by the plaintiff. The amendment applications are being filed only to delay and protract the proceedings. First, the Kalyan Ramchandra Learned Counsel for the petitioner and Ms. Brinda Verma Learned Counsel for the respondent. A perusal of the order, the perusal of the papers indicates that the application for amendment was filed after the completion of the evidence of the plaintiff, as also the evidence of DW1 and the matter having been posted for cross-examination of DW1. Correct. That is to say that the application was filed post commencement of trial. Correct. Proviso to Order 17, Rule 6 of the Civil Procedure Code makes it clear that unless the applicant seeking for amendment makes out a clear case of due diligence and the applicant's inability to seek for the amendment prior to trial commencing, the application cannot be allowed. The affidavit in support of the application under Order 6 Rule 17 does not give any reasons, nor does it establish any due diligence on part of the applicant. The only reason given is that after the deponent bracket DW1's chief examination, he came to know that the plaintiff's vendor society had purchased agricultural land in violation of section 79A and 79B of the Land Reforms Act. Correct. There is no argument made in the affidavit to establish due diligence or to establish the inability of the plaintiff to have sought for inability of the defendant to have sought for the amendment prior to commencement of evidence. Hence, in my considered opinion, the application could not have been considered without those arguments in place. Correct. The other reason, the reason given by the trial court for dismissal of the application is that this is the amendment sought for is only a reiteration or a written submission written argument as regards violation of 79A and 79B of the Land Reforms Act, which could be taken up by the defendant at the time of argument. I do not find any infirmity in the said reasoning of the trial court. The plaintiff, the defendant, can always take up such contention during the course of argument. Whether the said argument holds any water or not would have to be decided by the trial court on merits. In view of the above, I do not find any grounds made out to interfere in the order passed by the trial court. Hence, I pass the following order. writ petition is dismissed. The trial court is directed to consider the argument of the defendant as regards the applicability or otherwise of Section 79A and 79B of the Land Reforms Act during the course of final argument if raised by the defendant in accordance with law without being influenced by any of the observation made in this order. It is made clear that this court has not expressed any opinion as regards the applicability or otherwise of Section 79A and 79B to the given transaction.
Much of.
Number 32, third one is
32.
third one is
And of course, we will confirm to
number 33, Ganesh Kumar R.
Lord, back to you for the petition, Lord. No, the petition has become infactual. The suit has been disposed of in my favor. And so has the appeal also.
Suit has been decreed in your favor, Mr. Ganesh?
No, Lord, it has been, I was a defendant. There's a difference in the petition. Suit is dismissed.
Dismissed.
Please, Lord.
The Ganesh Kumar, counsel for the petitioner, submits that the suit in OS number 159 of 2007, out of which the above proceedings arises out of, has been dismissed in favor of the petitioner herein who was the defendant therein.
Please, Lord.
He further submits that the regular appeal also has been disposed?
Please, Lord. It has been disposed of.
RFA, na?
RA, district judge.
The regular appeal which had been filed has also been disposed in favor of the petitioner.
Please.
Sri Venkatesh Somareddy, the Net Counsel appearing for the respondent, also concurs with the said submission. In view thereof, the above petition is dismissed as infructuous.
Grateful, Lord.
34, Uday Shankar Rai.
Plus, I appear for respondent number 1.
But this is against, my lord, the order dated, impugned order, my lord, for amending the plaint, my lord, by adding an additional claim, my lord, for the suit for recovery.
Where's the application, Mr. Rai?
Yes, my lord.
Where's the application?
Application, my lord, at page 43, my lord, actually, of my lord. But that, what happened, my lord, before that, my lord, may lordship, I take your lordship to the plaint, my lord, 2 paragraphs. Where was, what was their original claim, my lord, in the plaint, my lord. Lordship, may kindly see the, at page, my lord, 18, ink page 18, my lord, of the plaint. Just 2 paragraphs, my lord, I will read, give the background of the case. Page 18, my lord, paragraph 5. The defendants failed to carry out repairs and rectification even after passage of 2 years and 8 months and subsequently abandoned the ship by signing off all crew members. On noticing of the same, the plaintiff intimated the defendant for taking action as it caused serious safety and security threat to the plaintiff port by letter dated 5/1/2011, and subsequently the vessel was arrested and taken over by the plaintiff by order dated 6/1/2011. The plaintiff issued a show cause notice dated 5/2/2011 to the defendant, calling due. The plaintiff replied by email dated 22/11/2011, rejecting the said request and asked them to pay the dues as per the demand. After adjusting the amount of 16,05,600 deposited by the defendants with the plaintiffs, the defendants were still owing rupees 2,54,38,674. A demand was made
on the defendant number 1 by the letter dated 14/10/2011 for the payment of the then outstanding sum of rupees 2 crore 54 lakh 38,674. Just 1 minute, I will pause. This is the original claim as per invoice dated 14/10/2011, my lord, where they had filed the suit for the charges of berth charges for overstaying of the ship, my lord. Then, my lord, the defendant number 1 then replied by the letter dated 26/11/2011, disputing the figure, though the liability was to pay was admitted. They sought permission for scrapping the said vehicle by paying only rupees 11,68,828 to the plaintiff, which was not agreeable to the plaintiff. The ship was in unmanned condition, which was a risk for safety and security of the port, and hence ship was arrested and detailed by the plaintiff. The plaintiff have no other option to recover its dues, notified by for public auction of the said vessel after intimation to the defendants by email dated 30/11/2011. The first defendant challenged the said proposal of auction in WP number 2338/2012 before the Honorable High Court of Karnataka, but the High Court declined to stay the auction. In the said petition filed on or about 19/12/2012, the defendant admitted their liabilities to pay the defendant through though disputed the quantum of the dues. Ultimately, the plaintiff has invited offers for the purpose of selling vessel through e-auction on 19/4/2012, conducted by MSTC Bangalore. However, in view of the interim order of the Honorable High Court, the auction process could not be completed till the said petition was disposed of. Finally, the said WP was dismissed on 19/6/2013 for non-prosecution. Therefore, the said vessel was sold to so-and-so company on 11/7/2013 by e-auction, and the plaintiff realized the sum of rupees 55,12,345 on 23/8/2013, still leaving a balance of rupees 1,99,026,329 from the defendants. The sale price is approved by the board of plaintiff on 12/7/2013. Then, my lord, the plaintiff issued a final demand notice on 8/5/2014, calling upon the defendants to pay the outstanding amount of rupees 1,99,026,329 within 30 days. So there are two demands, my lord, one at 2011 and one at 2014, before filing the suit, my lord. This was the total demand, my lord, they have raised, my lord. They filed the suit, my lord, calculating the interest and so, my lord, for 3 crore 12 lakhs. Now, my lord, after filing return statement and evidence was led by the plaintiff, they filed this application, my lord, at page, I point out to your lordship, my lord, for amendment, saying that, my lord, the calculation of the invoice, page, my lord, page 40, my lord, 40. In page, annexure E, my lord. There they say, my lord, the proposed amendments at para 1, add the following as para 8A in the plate. While calculating the charges at page 1 to 3 of the final bill, dated 14/10/2011, exhibit so-and-so, the normal berth hire charges were claimed at £6 per hour, but while billing for penalty, berth hire charges were claimed at £3.096 per hour instead of claiming per 0.6 per hour by oversight. The differential amount to be added to the plain claim comes to rupees 1 crore 86 lakhs 48,253. By adding interest to the rate of 16.5% from 25/10/2011 to 15/9/2014, the total amount due comes to 2 crore 76 lakhs 93,805. The corrected bill is filed separately. So, this was filed when? This was filed, my lord, 2016, 9/9/2016, my lord. Lordship can see the date, my lord, the next page. 16. That is much later, my lord, after the suit was filed. 2016. So, my lord, as on the date of this application, this was clearly time barred, because my lord, 2011 was. Pardon me. Stage of the suit. Pardon me. Stage of the suit. Stage of the suit. Namdu evidence agide. Plaintiff evidence agide. After plaintiff's evidence, our evidence agide. We are different. Plaintiff evidence is over. Then they realized, my lord, to file this application. Cross, I am not sure.
No, my lord, cross examination is not happening.
Evidence chief ಆಯ್ತು.
Evidence agide. Chief agide.
There is the order.
But order, my lord, at page, my lord, annexure H, my lord. There, my lord, the reasons, my lord, at page 52. Point number 1, my lord, page 52. The plaintiff come up with this application to produce revised bill issued by it to the defendant number 1 dated 14/10/2011. The suit is filed for recovery of berth hire charges from the defendants in respect of ship MV Seagull, which was berthed in the plaintiff port from 9/5/2008. It is specific contention of the plaintiff that due to oversight, the plaintiff prepared penalty berth hire charges claiming so and so per hour Therefore, it prepared revised final bill. That bill is very much necessary for adjudication of the dispute in this case. The defendants have not filed objections to the application. This is wrong, man. We have filed objections.
Where's the objection?
Court has given it's not filed. Objections hakidivi. Time warrant hakidivi. At page 45, my lord. Annexure G. Annexure G, page 45, my lord. The first paragraph itself, we have said, my lord, at the outset, the amendment sought by the plaintiff in the said application is misconstrued.
Any dispute about the objection?
No, my lords, I believe there is some error. My lords, what my learned friend is reading out is an order passed with respect to an application for production of documents. He should read the order prior to that. I think there is some pagination error in his petition. If you see the last order, the operative portion, it says IA number 5 filed by the plaintiff.
14 page.
The order is two pages before that.
Mr.
There is some
Rai,
pagination error there.
Please, my lord.
They have
Once-
filed objections, my lord. The court has considered the objections filed.
49, my lord. Yes, point number 1, my lord. The plaintiff with this application to amend the plaint by way of petition. It is necessary to note here that suit is filed for recovery of a sum of rupees 3 crore 12 lakhs 69,951. The plaintiff herein is New Mangalore Trust Post, Panambur. This suit is filed for recovery of the amounts said to be due from the defendant in respect of service rendered by the plaintiff in respect of vessel Seagull for the first defendant. It is specific contention of the plaintiff that while calculating the charges at page 123 of the final bill dated 14/10/2011, the normal berth hire charges were claimed at pound 6 per hour, but while billing for penalty berth hire charges were claimed at pound 3.096 per hour, instead of claiming at pound 6 per hour. It is only a mistake, and recently they found out this mistake. The plaintiff come up with this application to amend their plaint relating to this fact by way of addition. If the plaintiff is permitted to amend the plaint, no hardship or injury would be caused to the defendants for the reasons that they are at order to file additional written statement existing the claim of the plaintiff. On the other hand, plaintiff will be put to greater hardship in the event of dismissal of this application for the reason that it will be prevented from bringing it to the notice of the court about the material facts. Hence,
Mr. Bala, what do you have to say?
My lords, the contention that is raised, the ground of resisting the order of the trial court and the application for amendment raised by the petitioner is that a new claim is being put forth. But that is not the case, my lords. The claim that has been made, there was an error in computation. So
There are four issues. Number one, your application was filed after amendment started. After the
trial
evidence
has
started.
started, my lord. But I want to take benefit of Baldev Singh judgment, where, my lords, the Supreme Court has stated that, my lords, if the stage is still for producing documents, then, my lords, the application may be allowed in 2006. I'm sorry, my lords, I have
That
not
is for
filed. For amendment
production
of
of the
claim.
document.
Yes, my lords, because
Let us across. Just a moment. First, please understand what the question is before you reply.
Sorry, my lord, I'm so sorry.
Listen to understand and listen to respond, Mr. Bala.
I'm so sorry, my lord. Please.
That is the first aspect. Second aspect is the invoice was raised in the year 2011. You now contend in the year 2016 that the invoice raised in the year 2011 was a mistake. Therefore, I want to correct that mistake in the invoice and submit a revised invoice in the year 2016 after filing of the suit. That's the second aspect. Third aspect is there's never been any demand for that money from the defendant prior to this amendment. Now, these are the three things that you'll have to answer.
Yes, my lords, the query that the calculation, because, my lords, I had an opportunity to see the invoice, which was raised in 2011. The invoice actually says higher charges at the rate of $9 per hour. So the amount or the calculation that is mentioned is correct. It is only thing the amount has been wrongly mentioned. In the first page of that invoice, because, my lords, these are stamped notifications.
Bad luck. If there was a mistake committed, there's a mistake committed by you, not by the defendant.
Yes, my lords. I am not stating it as a mistake committed by the defendant, my lords. My lords, see, I am a port trust, my lords. I am governed by the notification of the TAMP, that is the Traffic Authority of under Ministry of Ports. They every year they tell me that this is the tariff that has to be applied. Now, my lords, the tariff as on that day in 2011 was $9 per hour, and that is mentioned in the bill. It is factually mentioned. In
Have
fact,
you taken
that is
any
the
action
reason.
against the person? Have you taken any action against the person who raised this invoice?
My lord, I don't have instructions on that, my lord. But I don't think so.
Then please, 5 years later, you can't wake up and say that there's a mistake.
No, my lord, if the invoice is seen, my lord, because I had the opportunity of seeing the invoices, they have only revised the calculation. The amounts, it is the final amount is where the calculation is revised, my lords. All the components are the same. There is no new claim I am making. See, my lords, the issue number 3, which is raised by the trial court, is whether the plaintiff is entitled to recover the amount under that claim. I'll just read out issue number 3, my lord. Issues are produced at page number 38, my lords. My lords, issue number 3, whether the plaintiff proves that they're entitled to levy penal berth hire charges with effect from 12/6/2008 against the defendants. If, my lords, I'm sorry, my lords. I'm sorry, my lords. I think there was some discussion. My lords, may I make a submission? No? Am I audible, my lords?
Yes, you are, Mr. Bala. Now you can go ahead.
Well, so one of the points that I have contended is this new claim, which is not a new claim. It is just a calculation error. Now, my lords, on this particular claim, an issue has been raised. That is issue number 3, which is available at page number 38. The trial court has framed an issue whether the plaintiff proves that they're entitled to levy penal berth hire charges with effect from 12/6/2008 against the defendants. Now, my lords, all I am saying is penal berth hire charges are to be paid, and they have to be paid as per the notification by the TAMP authority. Now, the only mistake that I had done, despite when I made the bill, despite following the diligent process, I had made a calculation error. Now, for that calculation error, my lord, all I'm seeking is the amount should have been so and so. Now it is so and so. It is an increase, my lord. It is not a new claim.
Yes. We'll deal with your submission.
Yes. No, my lord.
Deal with that.
That being said, my lords, and my lords, I have not raised a new bill in 2016, my lords. I have only revised the 2011 bill. Although the revision
Same bill has been revised in the year 2016.
Yes, my lords. Yes. The amount. Yes, my lords.
According to you, it's not a new bill.
Yes, my lords.
It's a mistake.
Yes, sir. But may I be permitted to produce the original bill and the revised bill, my lords? Because a bare perusal of it will
I'm going to
clearly.
adjudicate on the bill.
No, my lords. No, but my lords, what I want to say, my lords, is whether the amount that was mentioned in the original bill, that is the unrevised bill. I understand, my lords is saying you had issued a legal notice mentioning the amount mentioned in the unrevised bill. That being so, after so many years down the line, how can you increase the claim amount? Well, my lords, that my lords, I agree, my lords. But all I say is, my lords, this question the trial court may look into, my lords. I'm here on the limited aspect of amending my
Produce
claim.
the bill. We'll give you 2 days time. You produce the bill. We'll have it day after tomorrow.
Very well.
We'll consider it. If at all there's something, we'll consider that. But prima facie, right now, it seems to be.
Yes.
Okay,
I have one more submission. I'm so sorry.
Yes.
What happened along with this application, I had filed another application to produce that revised bill, which is what my learned friend was reading out, the order. That application goes unopposed, my lord. That application goes unopposed, and I am permitted to produce that the revised bill before the court. So under those circumstances, my lord, at one hand, the petitioner cannot say, I am opposing the amendment, but on the other hand, he says, I am okay for the bill to be produced before the trial court. He cannot blow hot and cold, my lord. So under these
That is going hot and cold according.
my lord, yeah, because my lord, he has not opposed the application to bring it on record, to have it marked in evidence.
Yeah, we will consider it.
Yes, I'll produce the bill. I'll produce it.
So basically 3 grounds. One, it is a mistake.
Yes.
2, it is not a new bill. 3, by permitting the production of the document, they'll be blowing hot and cold.
Well, all I'm saying is they cannot take contrary stance. He should have opposed the application on that.
You are entitled to make a submission. We'll have to deal with it.
Yes.
You make your submission. You are representing your client, you make your submission.
Well, I'll secure that document and produce it.
First, Sri Vijay Shankar Rai, then I transfer to the petitioner. And Sri Nikit Bala, then I transfer for response number 1. After arguing for some time, an inquiry as to how the invoice of the year 2011 should have been revised in the year 2016. Sri Bala seeks for 2 days accommodation to produce the said original invoice and the revised invoice and make his submissions. Dealers on 18 to
Obliged.
started. Started.
Number 35, S.V. Prakash.
Prakash ಇವತ್ತು ಬಂದಿಲ್ಲ. The counsel for the respondent is present and ready to address his argument. None appears to the petitioner. In the interest of justice, to give one more opportunity to the petitioner to be represented. We will on 2-3.
Number 36, Jagdish Mandargi.
I pay for respond number 1 to 3, my lord, in this matter.
Mundargi. The counsel for the respondent is present. Same order. None appears to the petitioner. We will on 2-3.
Much obliged.
37, R.P. Sadashivappa.
ಎಲ್ಲರೂ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ ಪೆಟಿಷನರ್ ಇಲ್ಲ ರಿವರ್ಸ್ ಇವತ್ತು ಜನರಲಿ ಪೆಟಿಷನರ್ ಇರ್ತಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರಲ್ಲ ಇವತ್ತು counter claim last opposition no counsel for the respondent is present and of the same order 3-3
38, Samir S.N. Samir.
None appears. We look on 4-3.